Welcome. My name is Steven Leskin. I am a divorce attorney in Portland. And this is the first of what I hope will be a series of informative seminars, webinars on divorce law in Oregon. Um, I started doing divorce back in 1992 when I was sworn into the practice of law. I've been doing it ever since. I'm primarily a litigator. Back in about 2015, I took a break from law, then I came back, and I found myself when I came back to practicing, working for essentially a divorce, not essentially, it was a divorce mill, and not liking it at all. I had a break in my employment after that, and when I came back to self-employment, I decided that there had to be a better way to do divorce. And so I started my one-day divorce practice. I'll talk about that a little bit. This is not intended as an infomercial, but I want to talk about how I got to where I am and what I've learned and how I'm bringing that now to the practice. I had a break in my practice. I came back. I started practicing litigation again, but also mediating. And um, the things that were really bothering me about the practice is what led me to start rethinking and reimagining how divorce should be practiced. So this is there's going to be a little give and take here, but since I'm not getting any response, I'm going to do both the give and the take. So my question is, and I'm going to answer it, is why is it that the lawyers and the courts handle something as personal as divorce? I mean, how did divorce end up in the courts? Like it could have been the therapists, right? I mean, they handle emotional things. It could have been you file a license for a business, you file a license for marriage. You need a marriage license, of course. Why is like divorce in the courts, but like dissolving a business is just a matter of filing a form? Why is it that the accountants don't handle divorce, right? I mean, it's essentially a lot of divorce is financial, so why not let the accountants handle it? Well, the reason is because divorce was always considered a contract. Divorce has always been considered a species of contract, and that's in Oregon law. Oregon law considers divorce as a civil contract because um, both sides have obligations. You accept a marriage proposal, you enter into a marriage, it's an agreement. And so the courts, in order to break an agreement, you had to go to court. And that's how the courts ended up with divorce because you were preemptively breaking your marital agreement. Oregon law, I just want to say it again, Oregon law still considers marriage a civil contract, and that's in Oregon statute. The word civil is interesting. Civil because there are other interests and other considerations besides just um, the relationship between the two people. Obviously, there are children, and the state has an interest in seeing that children are provided for. So that's what makes it uh, a civil uh, contract. So there are ramifications that are important to being a contract and being um, handled by the courts. One is that the courts are really good at ensuring that people's rights are honored. That's what courts do. The corollary to that is that takes a lot of effort and a lot of expense. And so you have attorneys who do things, including myself, who do things because they have to do it, not necessarily because it advances the case. So, for example, you may do a ton of discovery only to discover what the client already knew, which is important, but it's a lot of money to discover something that somebody already knew. Courts, you go to court, you cross-examine, you have your day in court, you have the rights to appeal. You have all of these rights that attach to this process that makes the process so cumbersome. And of course, it's necessarily an adversarial system, which means that you're paying somebody to run down your spouse in order to justify why you're paying that lawyer 300 or 400 or $500 an hour. Right. So it's not a system that's made for people. It's not a system that's made for people going through crisis, through the dissolution of their most intimate relationship, the most important relationship. It's a system that's designed to primarily enforce rights. And it's not necessarily the right mechanism for people who are going through divorce. So when I came back to practice, I thought I knew all this because I've been practicing for so long, and I thought about like how do we change this? How do we do this? How do we do this better? So I came up with my 1-day divorce, and I've been doing that for about 2 years now. But the things that I've learned doing divorce mediation are important, and they're important lessons here that I like to bring both to the public and to the profession. Um, One of the things that I've learned from the way I do mediation is that once people are given the information that they need in a way that they can digest, that helps them make their own decisions. And it makes them, if both people, both spouses are getting the same information, they're on the same page and they know how to work through problems like how to divide assets or how to divide debt. So information in a litigated environment is opaque. Information becomes proprietary. My lawyer knows, right? And he has to explain, or she has to explain it to me. I don't have access to that information. Lawyers don't typically like lay out the process because there's so much to know. Uh, Lawyers may have different takes on that information, right? I may look at the law one way, and my um, adversarial colleague may look at a statute or a case law differently. So information becomes proprietary. But when you break that down, it becomes easier for people to understand. And particularly if both parties are on the same page and have the same information, that gives them the tools to make decisions to resolving their differences easier. Um, the other part is that litigation itself is necessarily opaque, right? You have a lawyer, and whatever you tell the lawyer is privileged. Uh, and your spouse goes to the lawyer, and everything that the spouse tells that lawyer is privileged. And it's the client that holds the privilege. So the it's the opposite of transparent. And when things aren't transparent, that creates distrust and uncertainty. And it's exactly the opposite of moving things forward in a healthy way. Transparency works better. I mean, that's one of my takeaways from the things that I've been learning doing mediation. Another thing is that people are afraid of being taken advantage of. They're afraid that their spouse is going to pull one on them. They're afraid that they're not going to have all of the assets or know of all of the income. And litigation in that respect is good because you can get at that. Attorneys have subpoena power, right? So you can subpoena bank records to confirm that you know of all of the income. So that's what litigation is. But if you trust your spouse, the issue becomes, am I getting a fair resolution of this? And the only way you know that is by knowing the law and by knowing what the facts of your marriage are, right? So the process has to have a mechanism for uh, coming to the table and saying, we know we have all of the information and we know we have all of the law. Um, and so uh, that way you can assure people that they're within the bounds of what is reasonable. They're certainly in the bounds of what you would have gotten or what similarly situated people would have gotten had they gone to court. So, in the spirit of getting people more information, I'm doing these seminars now to counteract like these pitfalls or downside of litigation and the way divorce is uh, conducted now. And so this will be an ongoing series. I welcome your feedback. In order to protect privacy, and since this is the first time I'm doing this, I'm not taking feedback now, but I more than welcome people's calls. There'll be my screen will be up at the end of the webinar with my phone number. And if you have questions, just give me a call tomorrow. I'll be happy to talk to you. If you have comments, feel free to email me through the website. Always we'll look for feedback and we'll be appreciative, and we'll let you know how I use the feedback. Um, so to get into tonight's topic, this is fundamentals of divorce, and I want to talk about the most important part of the divorce, and that's the general judgment of dissolution. The whole divorce process from start to finish is designed to get to a document called general judgment of dissolution. And The general judgment of dissolution is the divorce decree. And it doesn't matter how you get there. There are basically three different ways, and that's what the topic of this seminar is. There are basically three different ways to get there, and we'll do deep dives on each of those. Uh, but what you want is a general judgment of dissolution. Some things that go into making a good general judgment of dissolution is that both parties buy into it, that both parties agree with it, what's in it. If it's imposed by the court, if you go the litigation route and a judge imposes a result, it's going to be the case that not everybody has a buy-in, and that may very well be the result of somebody who doesn't negotiate in good faith, or people having two vastly different views of how the assets, the money, or issues related to the kid should be handled. So one is that both parties have a buy-in so that it works. The other thing that makes a good divorce decree, what makes a divorce decree good, is that it anticipates future issues. So you have what's going on now, obviously, but you also have to think down the road what could happen, and does the divorce decree provide for contingencies? A lot of times, when I think about things, it's like, what if this doesn't work? What are we going to do? Or how are we going to have a final, ultimate decision on an issue if we can't agree on it, if the parties can't agree on it later? So there has to be decision-making mechanisms. There has to be provisions for when there's not agreement, or when one of the conditions falls through. So, for example, if parties agree that parties own a house and husband says, I want to buy wife out and I'll refinance, what happens in divorce decree if husband can't qualify for a new loan? Like the divorce decree has to count on those contingencies. Another thing about divorce decrees is that they're written for lawyers. Lawyers write for lawyers. Lawyers don't write for people. And uh, you want to be able to have a divorce decree that you can read. We'll talk about like the state forms in a minute, but the state forms are really they've gotten better, but they're not great. And I'll just say it, they're not great. Uh, I said it. So um, the issue is that sometimes you'll read the state forms and you won't know what it means. The uh, the lawyers won't know what it means, and if you have to go back before a judge may not know what it means. So a well-written, a well-drafted divorce decree that is understandable by people, that's written for people, that's written at a level that people can understand, is really, really important. Uh, there's a tendency among lawyers to throw every conceivable um, clause into the general judgment of dissolution, making them really thick and weighty. And most of it is verbiage that's not going to have any impact on the couple. Um, it's just the way that things happen and evolve. It's not the way I do it, but you'll see a lot of lawyers like drafting like really lengthy divorce decrees um, that cover really, really remote possibilities, and it just intimidates people, right? So it doesn't need to be in there. It shouldn't be in there. It just needs to cut to the trace and cover um, the contingencies that have to be dealt with. Um, so I want to discuss the three different ways to get to that important document, the divorce decree. And this is the heart of what I'm talking about, what I will talk about tonight. There are three different ways. There's uh, an uncontested divorce, there's litigation, and there's all this alternative dispute resolution. Let's start with the easy one, uncontested divorce. So I get a lot of calls. I'm sitting at my desk, and someone will say, my spouse and I agree on everything. We just want a simple divorce, and there's nothing that we disagree on. But they have a house, they have kids, maybe there's retirement accounts. There's too many things within those things that need in the details that need to be flushed out. And usually people don't do that. They don't know, they don't have the experience to do that. Um, a uncontested divorce is where there are no issues to be um, decided. Both parties agree that they want to get divorced, and that husband's going to get the dining room furniture, wife's going to get the bedroom set and the lawn furniture, And that's pretty much it. I do a lot of uncontested divorces, and I'm happy to do them, but I don't usually do them where there are kids or a home because there are too many areas for there to be disputes arising later. Uncontested is where there truly is no dispute. And so it's appropriate, for example, where there's no kids, there's no home, there's cars, bank accounts. Those are easy enough to um, divide. Where there's agreement on the debt, husband will take his debt, wife will take her debt, and that's fine. So uncontested divorce, uh, one of you, one of the parties will hire an attorney. The attorney drafts the general judgment of dissolution and the other six documents that need to be filed. And I'll come back to that in a second. And both parties read it over and sign it. That's an uncontested divorce. So uncontested divorce is appropriate where it's mostly you need the divorce and there's nothing to argue about or no details that need to be flushed out um, later, right? So, like for example, if you're selling a house, the divorce decree has to cover, what's going to happen to the equity, what's going to happen if the house doesn't sell, what's going to happen if there's costs incurred to repair the house for sale, or if there's liens, and so it's fairly involved to get all of that done, but that's usually more appropriate for like a contested situation, or hiring a lawyer to consult with who will then do the paperwork, but it's not necessarily uncontested. So that's uncontested. I mentioned the six other documents that need to go into a divorce. I'm just going to go through those really quickly now. Um, in in uncontested divorce and any simple divorce that just ends in a divorce decree, uh, there's something called a petition for dissolution, which tells the court that there's a divorce and notifies the spouse, the other party, what issues are going to be raised. So, for example, if husband files the petition, husband's the petitioner, uh, husband may want spousal support. So, husband has to give spouse notice that he intends to ask the court to award spousal support. Um, if there are kids, uh, if husband, same situation, wants custody, husband has to put into the divorce decree that husband thinks that he is an appropriate parent to have custody. Generally, the petition is very broad. It can just say, division of the debts in a just and proper manner, and just and proper is code language. That's the standard that the court uses. It's found in the statute. Uh, so it's just to divide the debt in a just and proper manner, divide the real estate and the personal property in just and proper manner, um, and make a custody decision based on the best interest of the kid. Those all need to be in the petition. Um, the response to that is called a response, and it just says I agree or I disagree, or I want the children and I want you to pay my attorney fees. That's the response. Uh, if it's an uncontested divorce, it's not necessary to file a response. The other five documents are you have to file a something called a notice of confidential information, and that's just telling the world that there's a confidential information form filed for husband and wife. The confidential information form includes driver's license, employment, and social security, and that information is segregated. It's not open to the public. It used to be that all of that information would go like right in the divorce documents until identity theft became a thing, and then that information went privately segregated, confidentially, I should say, into other documents. Um, and then there's a vital statistics forms that needs to be filed, and then finally the general judgment of dissolution and a declaration uh, um, under oath of the basics of the divorce, like that, ages and phone numbers and addresses and things like that. That's done by declaration. So those are the seven documents that need to be filed for an uncontested divorce. I don't see anybody raising their hands, so I'll move on. Um, that's all about uncontested divorce. Litigation. So you and spouse don't agree, uh, or it's time for the divorce, and uh, the wife files the petition for dissolution. The petition for dissolution is what gets the divorce going. It's what says to the other spouse, this is what I intend to ask for. It tells the court that there's a court case, and um, it's what initiates. It's the petition. It's what initiates the divorce. The petition is served usually by the sheriff on the spouse, and then the spouse has 30 days to respond. We talked about the response a little bit ago, but you do have to file that within 30 days, or you lose by default. And that sadly it does happen, that a spouse just won't respond and the other party just prevails. Um, this second part of it's not really divided into parts, but the second aspect of litigation is discovery. And the way I think of discovery and the way I explain discovery is that you're creating an inventory of all of the assets, all of the debt, and all of the income of the marriage. And it's important to have that inventory so that the court can make that just and proper division of assets and liabilities. And in Oregon, uh, our neighbors, North and South, are community property states. Oregon is not. So that means that um, basically, the longer you're married, the more equal or equitable the division of assets will be. That's not entirely true. Oregon law is way more nuanced than that, but that's the way to think about it. So if you have a short-term marriage, generally the courts will try to put parties back into the position that they were uh, prior to the marriage. In a long-term marriage, the court's going to attempt to split all of the assets equitably, meaning evenly. In that mid-range marriage, 5, 6, 7, 8 years, uh, um, the court's going to just try to make things right, and there's no better guidance than that. It's going to, the court will look at the intent of the parties in trying to fashion a distribution that reflects the will of the parties going into the marriage. So if the parties intended and their actions showed that they intended to live separate financial lives, the courts will honor that. If, on the other hand, the parties fully integrated their financial lives, the court will honor that also and try to put the parties back to the position they were um, before the marriage. So um, if so, both parties are required to produce things like tax records and income statements and social security records and bank records and credit card reports and credit reports, and just on in the course of litigation. And that is intended to ensure that all of the information about the marriage is on the table so that the court can make a just and proper division. Lawyers are particularly familiar with this because in many areas of law, this is a very familiar pattern, and it's a basic way that people make decisions. You get everything together, you apply the rules, and then you come to an outcome. And it's no different in divorce, period. You'd find that same process if you were dividing up a business or if you were in bankruptcy court. So that process is very familiar to lawyers, and it's a very intuitive process if you take a step back from it. At the outset, I said that there were a lot of things that lawyers do that maybe we don't need to do. And the biggest one in my book is the amount of discovery that we require from people. Oftentimes we don't discover anything new. Sometimes we'll discover that a spouse had an OnlyFans account, and who cares? It doesn't matter to anybody. Uh, Rarely do you find that somebody's hiding assets or hiding income. Uh, People tend to know their spouses. Sometimes they suspect they are, and you need to go through the discovery. But oftentimes lawyers will spend thousands of dollars to do discovery and not discover anything that they didn't know beforehand. So that's like one of those things that the court, you have to do it. You're remiss if you don't. You're possibly negligent if you don't. And you possibly may be facing an insurance claim if you don't. But it's just one of those things that takes a lot of time and a lot of effort. It doesn't really usually provide too much that's fruitful. So you go through discovery, and then there's required uh, effort to resolve the case. The courts want people to go through some type of dispute resolution process. Usually it's mediation. If there are children in a marriage, uh, uh, in most of the counties in the Tri-County area in Oregon, and generally throughout the state, um, you are required to go through court-ordered mediation, and it usually doesn't cost anything, but it will resolve issues pertaining to the kids. If there's no resolution through mediation, supposing the parties are too far apart on an issue like spousal support or how the debt's going to be divided, at that point the parties need to gear up for trial. And trial can be it certainly can be expensive. I know in my practice, I tell people that a day in court will cost about $15,000 for all the prep and the day in court, and that's probably uh, true for most attorneys. That's not an unreasonable number to expect, and it could be more, could be less, but that's generally what I tell people. Um, Court is stressful. It's public. There's a lot of pressure on people, and it's the time when a lawyer is going to cross-examine you. It's a time when um, you things in the marriage that you may not want to be public will come out. And so um, trial is not about character assassination. It's about dividing the assets and liabilities. It's not your character is not on trial, but like I mentioned, there may just be things that come up that you don't want. Plus, the real risk of trial is that you're going before a third party who may or may not know your case, may or may not know the law. When I say a third party, I mean a judge. Uh, and I've been before enough judges to know that the results are not always predictable. In fact, sometimes they are very unpredictable. And so you take your case to trial, you pay your dues, and you take your chances. And sometimes you don't get the result that you want. And that is all about litigation. It's expensive, it's public, it's time consuming, it's stressful. In Multnomah County, uh, it could take you 9 months to a year to get to court. Something that happens in Clackamas is that you trial comes up at 6 months, and you go down to court, and they don't have a judge for you. And that's happened to me more times than I care to think about. And then they don't schedule you out for another 3 months, 4 months. That's kind of that happens, and everybody's in their nice clothes and ready to go and geared up and ready for the day, and then you get there and there's no judge. And that happens in the courts. So at times the process itself is unpredictable. I think the courts are getting better at that, but it still happens. So we talked about uncontested divorce being appropriate where there's not a lot of details to work out. We talked about litigation when you can't um, get a resolution amongst yourselves. I will add, I didn't mention this, I will add that um, most cases settle. Most probably 80% of cases settle or settle on most of the issues, and maybe there'll still be one issue that you go before um, a judge on. And like for example, the parties can't they can agree on splitting the proceeds from the sale of the house. They're going to sell the house, and husband's going to get half, and wife's going to get half, and that's easy. And then they agree that husband's going to take the American Express card that has $5,000, and wife's going to take the Visa card that has $5,000, and that's easy. But they can't agree on what's an appropriate amount of spousal support. So they'll agree on everything except the spousal support award, and so they may just take the case to court on that. That's not uncommon. So um, to get to that point of, it's a lot of work to get to that point of settlement. And um, two attorneys working together, two practical attorneys working together will get a case settled. Two people who still have goodwill for each other and realize that they don't have to kill each other to get divorced, they'll get it settled. But there those times when people have well-grounded differences in opinion. There's nothing wrong with that at all. That's healthy. That shows that people are taking care of themselves. Um, but they can't get it done, and they require a judge to make the final decision. So I want to so we talked about uncontested divorce. We talked about litigation. Now we're going to talk about alternative dispute resolution. And so after litigating for you know, 30 years almost, um, I have retooled my practice to be doing more mediation. And um, I'm going to come back to that in just a little bit, of course. But there are four general ways of doing alternative dispute resolution, say three and a half. I'll talk about the half. There's mediation, there's arbitration, and there's a method called collaborative divorce. So mediation is uh, people meeting under the auspices of a mediator, and a mediator is a trained neutral. A mediator is somebody doesn't have a dog in the race, or pony in the race, or a snake in the race, whatever, and we'll go back and forth uh, between husband and wife, between spouses, and say, where do we go? How do we work this out? And um, the mediator works to keep the power balance equal. The mediator works to keep both parties making informed decisions. The mediator works to uh, keep the dialogue going until there's a resolution. Um, uh, it's a process of going back and talking through your difficulties with your spouse. It's trying to get consensus out of conflict, right? That's the magic of mediation. There are three different types of mediation, and there's four types of mediation. And let's start with facilitative. Facilitative is what I just described. That's kind of traditional mediation where the mediator doesn't put his foot or her foot on the gas. They just kind of like work with the parties to get the parties to solve their differences, and they go back and forth until there's agreement on each of the issues. Another type of mediation is called evaluative mediation. Back when I was a personal injury attorney, evaluative is what the mediators did. So you go in and say, you were in a car accident, and the plaintiff's attorney would say the case is worth $150,000, and the defense attorney would say no, it's worth 2,500, and the mediator would go back and forth and say um, to the plaintiff's attorney, I think it's closer to, I think if I were to try this case, you would get, $50,000. And then I'd go to the other side and say, if I try this case, you're going to get, $100,000. So that's exactly, you heard that correctly. So the mediator would fudge things until they came to an agreement, right? You risk that they're outlining the risk to both sides of what the possible outcome could be. So that's evaluative. Uh, in the family law setting, uh, evaluative mediation is not really used. Um, it's hard to say that the judge will say this or that. Uh, Family law evaluations, evaluative mediation is not the norm. Another type of mediation is called transformative, and this is popular in some circles. And this is attempting to bring people who disagree with each other together to get them to a like mind where they can have empathy for the other person's perspective and come to an agreement. So in transformative mediation, you're trying to build enough of a rapport with both the parties that they can see um, what the other side's dilemma is, and help work where the parties can work together then to find that common ground. And um, in transformative, where there's an aha moment, like, I see where you're at, that's considered success. The people don't have to leave as friends, they don't have to leave as bosom buddies or anything like that, but it's like where that light bulb goes off and says, okay, I see where you're at. And that that trait, that skill of getting people to that moment is always useful in any type of mediation. It's just not a type of mediation. It's just not the dominant way that divorce mediation is practiced. The way I practice mediation is um, it's called muscular mediation, and I use the law as guidelines for people. I want people to know going into mediations where a court would likely come out. So, like for example, I will say that under these circumstances, I say this to both parties together, so that everybody hears it at the same time and hears the same thing. That in these circumstances, this is what the law is. I might not say this is what a court will do, but I will say this is what the law is, and that gives people guidelines to know that they are within the bounds of fair and that everybody's playing on the same field. I'll also do a little bit more problem solving to make sure that like the I will do more problem solving with people. It's their case, but I will help people see different ways to approach a particular issue in a way that's pragmatic. So those are the different types uh, of mediation. Um, something so, some other things that I do differently is I look at mediation not as a fact finding, not as a day of fact finding. I look at mediation as being um, you have to have all your facts established before you get there. And that way, both the parties have an opportunity to dispute what the facts are. So, for example, if husband says there's $75,000 in the retirement account, wife can say, no, I think there's 100. Husband's got to come up with his retirement statements to prove that no, there's 75,000, or a wife can say, there, I thought there was 100 and there is. So um, my approach is to get all the facts agreed on before we get to the mediation. And I found that once those facts are agreed on and up on a board, it makes it easier for people to say, yeah, I'll take that. Yeah, that's my debt. I'll take that. Um, and then by the time you get to the mediation, you've done a good portion of the work. You're not filtering through facts or things that are, people are already thinking in their mind they're going to do. Um, arbitration. Arbitration is different from mediation. Arbitration is private, and the parties hire an arbitrator to decide their case the same way a court would. So essentially, you're hiring a private judge, and the arbitration could be as strict as the Oregon rules allow, or as lenient as the parties agree. And so parties will bring their evidence, they'll make opening statements, they'll present their evidence, they'll present their witnesses and documents, they'll get cross-examined, then the other side goes, and then the arbitrator makes a decision. And in divorce cases where there's arbitration, it's always binding, meaning that the arbitrator, you wouldn't go through all of that just to say, well, I don't agree with the result, therefore we're going to go to the judge. Parties agree that that's binding. So the parties choose the arbitrator makes a decision, and then that's reduced to the general judgment. Um, and then finally, there's collaborative. And collaborative is a species of negotiations where parties meet with their attorneys and they attempt to resolve the differences in the divorce. The catch is that if they can't get it done, then both of the attorneys have to resign and the parties start over. And so they're using the threat of more money, spending more money on attorneys to pressure people to uh, um, get to a settlement. My I know several attorneys who do collaborative work, and I support them, and they're great at what they do. I don't particularly like that model because it still will give um, an advantage to whoever's got more money and more fortitude to continue the process in the event that the parties can't agree. And I just don't think it's a good model to say, oh, you got to start over again. It just seems kind of wasteful. So that's mediation, arbitration, and collaborative. The way I do mediation, my one-day divorce mediation, I do a hybrid mediation arbitration. So after a day of mediating, um, if parties can't decide, then I step into the role of arbitrator and I make the decisions for people. same as an arbitrator would, same as a judge would. I apply Oregon law to come to a resolution, and that way people know that they're going to be done within a set time frame. One of the drawbacks of mediation is that you can mediate and you can mediate and you can mediate, and there's no certainty that you'll ever get a an agreement. And so my approach is to say you got to set time. If you can't do it, I make these decisions for you. I will use my best efforts uh, um, to get there, to get a result that a judge would. Um, and that just gives people a certainty to know that they're going to be done at that time. So that covers it. That covers uncontested divorce, litigation, and alternative dispute resolutions. I hope you found this informative. Please give me a call. I will be happy to talk through questions with people. Um, my contact information will come up in just um, a minute or so. And thank you for attending. I'll do another seminar late November after Thanksgiving. So thank you very much for attending, and I'll look forward to hearing from you.